This conference will now be recorded.
So I'd like to welcome everybody who's joining me tonight on May 2022 to celebrate National Elder Law Month. And tonight we're going to talk about what adult children need to know to help their parents prepare for different issues that arise during the aging process. You know, it's especially challenging for those of us who are trying to be supportive of our parents, and at the same time, we may be caring for our own children of varying ages. And the question is, how do we create balance in our lives? Some of the challenges that I hear from my clients and their adult children have to do with finances. How is the parent or the grandparent going to pay for care they need? There's the stress on the adult children of seeing what their parents are going through. Many adult children are bringing their parents or their grandparents into their home. We certainly experienced a lot of this the first year and a half of COVID. And then there's the challenge of us, the adult children, taking care of our own future, planning financially for our own retirement. I don't think any of us are going to be surprised to hear that the statistics show that the majority of caregivers in the US are between the ages of 18 and 34, approximately 11 million caregivers. We know that many times the spouse is the primary caregiver, and if that spouse has already passed or is not well themselves, then it's the adult children or even the daughter-in-laws and son-in-laws. We're going to talk tonight about issues having to do with, well, how do we pay for medical care? What is covered and what is not covered by Medicare? What the benefits are of purchasing long-term care insurance when we're young. And I do want to emphasize tonight that while many times it is assumed and expected that women will be the primary caregivers, it's really important to try to find other solutions other than having women leave the workforce, because when they do leave the workforce, they are ultimately sacrificing 20 to 30% of their earnings long term, and that's going to affect how much we get from Social Security when we're ready to retire. So I have 5 goals for us tonight. The first goal is to share with you what to look for. What are the potential warning signs that are going to tell you something is happening and it needs to be closely looked at? Knowing what the issues are and being able to address them before they potentially become a problem or an emergency. Our second goal for tonight is to understand the legal tools that are available to help you and your families navigate successfully through the aging process. And that involves being ready to think about the future, to think about long-term care planning. I'm also going to share with you community resources that are available to everybody to help you meet those challenges. And I'm going to share some tips at the end about how to have the conversation with your parents and your loved ones early on. Because I find that when we engage our parents and our elders early on, it shows them that we respect what is important to them, and we want to know what their preferences are. That way we can hopefully come to a middle ground of finding the solutions that work for everybody. So we're going to start tonight's discussion talking about timing. And timing to me is everything. And the reason for that is that whether you come to me or another elder law attorney, We can give you all kinds of solutions and planning options, but if you can't implement those solutions, then the advice doesn't mean anything. So timing is important because in order to implement different legal solutions, your parents and your grandparents need to be mentally competent. They need to be aware. If they're not, then we need to hopefully have in place a very well-written, durable power of attorney. And we're going to talk in a little while about what this document is and why it's important. So I say timing is everything because in order for your parents and your grandparents to sign a legal document, such as a durable power of attorney, giving you permission to make financial decisions for them, they have to understand what they're doing. They have to be willing to give you permission to make financial decisions. When people are already having cognitive impairment, maybe there's a diagnosis of Alzheimer's or dementia, maybe they're very forgetful, it could be too late at that point to put these documents in place. So the earlier, the better chance we have to create a really solid legal plan. Now, what are some of the benefits when we plan early enough? Well, the first thing is we avoid, hopefully, being in a crisis situation. Because when we're in a crisis or an emergency situation, we as the caregiver may not be thinking as clearly as we need to make the best decisions. We might also be in a position that if our parent or our grandparent did not put a durable power of attorney in place and it's too late, we may end up having to incur a lot of legal expense to go to court to become their guardian in order to make medical and financial decisions. So by planning early, we are actually saving money in the long run, money that can be used to take care of our parent or our grandparent. We're also able to promote helping people stay independent as long as possible and protecting their privacy and their dignity by allowing them to be involved in the decision-making process. So let's talk about what might be some warning signs. And if we see these, what do we do? So common warning signs that I see are individuals who are forgetting to take their prescriptive medication timely and correctly. Meaning, if the doctor says you take this pill once in the morning and once in the evening at mealtime, and you're noticing that they're forgetting, they're only taking it once a day, they're taking it at the wrong time of day, that could be a warning sign that something is happening cognitively. Or you might see that a prescriptive medication hasn't been refilled in a while, or that the vial is very full and it really shouldn't be because you look at the date that it was filled and half or more of the prescription should have been taken by that time. You also might notice change in appetite, forgetting to eat, or forgetting that they ate recently and they're hungry again. Or you go to visit and you open the refrigerator and you see that the food has gone bad. You might also see signs when visiting that mail has not been opened, it's been piling up, or the mail that has not been opened has been put into the garbage, hasn't been addressed, bills have not been paid. Maybe you notice that there is a warning notice that the electric is about to be terminated. Or you might go into the house and there is no electricity at that point in time. So these are usually warning signs that something has changed cognitively and possibly functionally. The parent or the grandparent is not behaving as they normally would. So one of the first things to consider is locating in your county your local memory disorder center. Now, if you live in a metropolitan area like Broward County, Palm Beach, or Miami-Dade, you will probably have your choice of more than one memory disorder center. And many times they are associated with a large hospital in the county. So you want to reach out to them and find out what the process is for scheduling some cognitive testing, depending on whether your parent is on traditional Medicare or perhaps they're on a Medicare Advantage plan or an HMO, will determine if they first need a referral from the primary care physician. I do suggest that this is probably the time when you need to sit with them and delicately tell them what it is that you're noticing and that you're concerned for their well-being and their safety, and you would like to schedule cognitive testing, and you will go with them, or somebody else in the family will go with them so they feel supported. At the same time, you might want to reach out to the primary care physician and schedule a full medical evaluation, because you want to be able to either rule out or pinpoint what could be the cause of what you're observing. For example, is there a cardiac issue? Is there less oxygen flowing to the brain that is affecting cognitive abilities? Or is there a chemical imbalance? So you want to work with both the medical doctor as well as the memory disorder center. And you want to tell both physicians, the neurologist and the primary care physician, of the other person, because you need a team of professionals that are going to communicate with each other, sharing information to determine how to approach whatever the diagnosis is. Now, this is also a good time to talk with your parents and ask whether they have a legal plan in place and where are those documents kept. Because at this point in time, you might need to know, are you the person that is legally authorized to make medical decisions, to make financial decisions, or is it somebody else? And if it's somebody else, is that person willing to take on the responsibility? So knowing where the documents are, locating them are very important. Sometimes after a client leaves an attorney's office, they put the documents away, but they don't share copies of the documents with the people that are actually going to be the decision makers. So you want to find the documents. You also want to make sure that any healthcare legal documents have been or will be provided to the healthcare providers and put in their charts. It's also a good time to start to understand what the finances are. Now, finances is a very delicate topic for all of us, no matter what our age, but it might be particularly sensitive for our elders. They may feel that it's invading their privacy. So realize that it may take more than one discussion. You may have to leave it alone and go back to it. You know, sometimes it's taking baby steps to gain somebody's consent, somebody's trust and confidence. So use this as your checklist and maybe approach it in stages. Finding the legal documents, asking them to share the financial information, finding out what health insurance they have, what's their primary, do they have a secondary that might have been provided by their employer, or maybe they themselves, when they retired, they purchased a supplemental policy. It's also a good time to ask whether they had previously made any type of funeral arrangements and find that contract so you know what their desires are, you know who the arrangements were made with. And since we are living in an age of technology, it's a very good idea to scan all this documentation so you have another reliable source in addition to the paper copies. If you know that a parent or a grandparent served as a veteran, it's also a very good idea to ask, where do they keep their honorable discharge papers? Because when we're talking about how we're going to pay for long-term care, we might want to access veteran benefits. And having what's called the DD-214, the honorable discharge papers, is very important. Now, if you are finding that your loved one maybe is not handling their finances well, or you have concern about them being exploited or becoming a victim, you may then want to apply to the Social Security Administration to become what they call a representative payee. This means that the Social Security benefit, whether it's retirement or disability, would be paid in care of you to take care of for that person. Now, to become the representative payee, you're going to need a letter from the doctor on the doctor's letterhead explaining what the doctor's concern is as to why the elder is not capable of handling their financial affairs. You can schedule an appointment either by calling the 800 phone number for Social Security or going to their website, ssa.gov. Now, there may be two options. One option would be to open a Social Security account where they will electronically deposit the benefit. Or more recently, Social Security has been using an electronic card, and every month the benefit is electronically transferred to the card. So you want to ask about your options and then make an informed decision. So in the beginning, when we are assessing the situation, we're noticing things when we visit or when we talk on the telephone, you want to know what resources are available to help you. Because even if you are a healthcare practitioner or you're an attorney, you probably haven't experienced anything like this before, and there's nothing in your training that has prepared you for what you're going through. So resources are extremely important. It's putting together a team of professionals that can help you create the best plan for your family. So one of the first resources you want to be able to access are called aging life care managers. Now, early on in my career, they were referred to as geriatric care managers, for the simple reason that many of these professionals were working with a population over 65. They did change the title to the profession because as time has gone on, there are aging issues that can arise earlier than age 65. We have people who are diagnosed with MS. We have clients that are diagnosed with early Alzheimer's in their 50s. So aging life care managers have either a social work background or a nursing background to help families and individuals navigate through the healthcare, the medical challenges. Everything from, can my loved one stay at home? And if so, how do we make it possible and how do we make it safe for them? If the children or the grandchildren are living out of state, let's say the parents are here in Florida, the children are in the Northeast, an aging life care manager can be a great resource to be your eyes and ears here in Florida and also help coordinate the medical care, make sure that the checkups are being made, that there is transportation to get them to the appointments, that the aging life care manager goes with them to be able to speak with the doctor and then be able to relate to you what took place. So I'm providing you with a link that is for Florida. If you live in another state, you can Google Aging Life Care Managers, and there is a national association that can then direct you to your state chapter. Now, how do you know whether you should work with an aging life care manager that's a social worker as compared to a nurse? Well, it really depends on the type of issues that your loved one is experiencing. I would say that if there are chronic medical issues, you probably want to work with a nurse care manager because, oh, Dorzell, you're saying you can't see the slideshow?
No, it was showing, and then all of a sudden it came back to you, Stephanie.
Okay, Maria and Olga, can you give me some feedback? Are you able to see the slideshow?
Yes.
Okay, thank you.
Yes.
Dorzell, you might want to just check your internet connection then.
Okay, I'll try that.
Okay. All right. Now, if your loved one is having not so much the medical issues, but maybe they need some coordination of services, they need supervision and oversight, then it'll probably be enough for you to work with a social worker, care manager. Another great resource, and you're going to find these all over the country in every county, is an Aging Disability Resource Center. Now, this is what we call it in Broward County. In other counties, they might refer to it as AAA, which is an acronym for the Area Agency on Aging. So think of them kind of as a hub of information. They will be able to tell you where there is in your parent or your grandparents' locale a senior center that they can attend, maybe a memory care center to attend during the daytime. They can help arrange for Meals on Wheels and other things. So they are a great resource of information of what is available in that county for your loved one. And again, because we're living in the age of the internet, you're going to be able to find these online, and you'll be able to see all the different kinds of services that they can provide and help you with. In addition, there are professionals that can help you with placement if, for example, your loved one can no longer stay at home safely, and maybe it's not an option for them to move in with you or a family member. So these individuals can tell you, first of all, what level of care your parent is going to need, and that will determine whether they need assisted living, skilled nursing, or independent living. In addition, every state is going to have a website. In Florida, it is the Agency for Healthcare Administration that oversees and licenses facilities. So you can go to the state website and get information about how many beds does the facility have, what beds are licensed for Medicare coverage, what beds are licensed for Medicaid. It will also tell you when was the last on-site survey, because that is done yearly. And at that survey, were there any deficiencies noted? What were the deficiencies and were they corrected? So there's a lot of good information that you'll be able to get from your state licensing agency. In addition, if it's possible to keep your loved one at home, whether it's their home, your home, or relative's home. It might be that they're going to need some home health services. So I want to talk for a minute about what is the difference between a home health agency as compared to a registry. An agency means that the home health aides or the certified nurses aides are actually employees of the agency. So that means the agency is responsible when they pay the employee to remit federal payroll taxes to IRS. You do not have to do that. It also means that the agency has workers' compensation insurance to cover if there are any injuries that the employee sustains while on the job. Let's say, for example, there's a home health aide assisting your parent in getting out of bed, and your parent all of a sudden loses their footing or they're weak, and at the same time that they are going down, the aide goes down with them and injures their back. They are going to report to the agency what happened, and they're going to be covered under that workers' compensation policy. With a registry, the aides, the nurses are independent contractors. They are not employees of the registry. So the registry is not remitting any employment taxes on their behalf. So that means you need to consult with your accountant and have your accountant assist you in remitting those payroll taxes. You don't want to have a problem with IRS. The other potential problem when you go through a registry, yes, it may be attractive because it's going to be a lower hourly rate, but the reason for that is they're not taking out employment taxes. What most people who work for a registry don't understand is that if they themselves are also not reporting their wages to the federal government, they're not earning what we call quarters under the Social Security system, which entitles them to Social Security retirement benefits or Social Security disability benefits if they're injured and they can't work. So you don't want to be in a position where you've got somebody through a registry, they are injured while they're in your parents' home or your home, and the next thing you know, they're making a claim against you. That may or may not be covered under your homeowner's insurance policy. So there are a lot of benefits and protections for you and your elder by going through a licensed home health agency as compared to a home health registry. Now, if your loved one is going to be moving out of their home, perhaps downsizing, maybe moving into a retirement community, there are specialists that help seniors with the packing, the moving, setting up the new home. That can take some of the pressures off of you. So, when we as the adult children are in the position of becoming our parents' advocates, we have to learn how to be an effective advocate. And it's not something we learn in school. You can't necessarily learn it through a book either. So it's important to learn how to advocate, how to navigate through the healthcare systems. That's where working with a good care manager, an informed elder law attorney is going to help you be an effective advocate to understand what can you do with the document. Are there any limitations in the document that has been written? And how do you best work around those limitations? So for example, if You are the designated healthcare surrogate who's going to make medical decisions, and your loved one is in a hospital and you're finding that you're not being recognized. You might need to go speak with the risk manager at the hospital. So don't be afraid to go above the people you might be dealing with on the floor who may not understand what the legal document means. Go talk to risk management. Go talk to administration. Show them the document. Tell them what is happening and why you feel that your decisions or your requests are not being honored. So when we're in this process of assessing the situation, what's going on, it leads us to the discussion of what is the best and the appropriate residential environment for our loved one. So how do we determine this? Well, we look at two major functions. One is referred to as activities of daily living, and the other is called instrumental activities of daily living. Activities of daily living are things like, can the person eat by themselves? Can they cut their food? Can they feed themselves, or does somebody else need to do that for them? Or do they need to be cued, to be reminded? Is the person able to independently or with assistance groom themselves? That means to shave, to wash their face, brush their hair, brush their teeth. Are they able to bathe with or without assistance? Are they able to toilet independently? When it comes to getting dressed, do they know that a top goes on the top part of the body and pants, skirt, or shorts goes on the bottom? Or are they mixing that up? Are they able to safely transfer out of a bed into a chair, or to be able to stand up from being seated in a chair? So when we see that people need assistance with two or more activities of daily living, that might indicate that they need a level of care we refer to as assisted, whether it's assistance being provided in the home or an assisted living facility. Whereas if somebody does not need any assistance and is independent, then they might be a candidate for an independent living community where meals are provided, maybe housekeeping services are provided as well. But other than that, the individual has their own independence in their apartment. Instrumental activities of daily living have to do more with the cognitive function. Is somebody able to use the telephone, whether it's to dial for help, for 911? Can they use a computer? Are they properly managing their money? Are they writing the checks, paying the bills online? Are they forgetting to go to the doctor's appointment? Did it get missed? Did they not show up? Are they able to arrange for transportation to get to places where they need to be if, let's say, they don't drive, they gave up their license? Those are the things that we want to look for. That's going to give us a better understanding of where do they need the support and what kind of supportive living arrangement is going to best help them be safe as well as get the quality of care that they need. So what are some of the options to help us address the residential needs of our loved ones? Well, most people do want to stay at home with assistance. This may also mean that you need to talk to your loved one about having some sort of a system, a device in the house that if they are alone, let's say at night, and they were to fall, they would not be on the floor for hours without somebody coming to help them. It might also mean that you need to ask them for permission for you to install a camera security system in the home, in addition to having a medical alert system so that they can get assistance right away should they fall and have difficulty getting up. If your loved one is going to stay at home, it's helpful to know, well, what's available in the community to keep them stimulated. And now that we're coming out of COVID, the adult day centers are reopening. That's a place where they can go and engage with their peers in a variety of activities, whether it be current events, arts and crafts, cooking. You're going to find adult daycare centers in the 4 quadrants of every county: north, south, east, and west. You're also going to find memory care centers. So if your loved one has been diagnosed with a cognitive impairment, the memory care center is going to have trained staff who know how to work with people with memory issues. Another option, if you feel it's no longer safe for your loved one to stay at home, would be to consider a continuing care retirement community. Now, these are communities that provide the 3 primary levels of care, starting with independent living. Then if somebody needs assistance, they could move into the assisted living part of the community. And if at some point in time they need the highest level of medical care, which we refer to as skilled nursing, then they could then again move from assisted living to the skilled nursing center. So a continuing care retirement community allows a person to age in place knowing that at any level of care, it can be addressed by the staff in the community. Some people may just go into independent living by itself, not necessarily associated with a continuing care retirement community, or they may first go directly into assisted living. In Florida, we have something that's unique. It's called adult family care homes. And these are, as it says, a private family home environment that has been licensed to provide care to generally no more than 6 residents. So the residents' needs can be met when it comes to cooking, cleaning, housekeeping, linen service, and assisting them throughout the day. This is another option for aging in place if somebody, let's say, cannot afford the cost of a continuing care retirement community. So that's another option. Now, if somebody needs a skilled level of care that can only be provided by a licensed medical professional, such as an RN, an LPN, or a physician, that's going to require a level of skilled nursing. Or if, let's say, somebody has medical equipment, such as a feeding tube or a colostomy bag, that needs to be taken care of by a nurse in order to make sure the area is kept clean and it is avoiding any possibility of infection. So how do we pay for long-term care? I'd like to talk about a misnomer or a myth that many of our older clients and loved ones have. And it's a myth because there's been a misunderstanding for a very long time about what Medicare really is about. Now, Medicare was developed in the early 50s. And if you think back, people did not have the life expectancies that they do today. Probably the average actuarial life expectancy was somewhere in the 50s, maybe the early 60s. So Medicare was designed really to address short-term medical needs. It was never intended to be the answer for people who have a chronic illness and are going to require long-term care. So if a person goes into a hospital and they are admitted, and that's the key word, you have to be admitted to the hospital. You cannot just be in the emergency room. That does not count. If you've had a 3-day hospital stay and you go directly from the hospital to a rehabilitation facility, there is the possibility that Medicare will pay for up to 100 days while you are in the rehabilitation facility. Now, day 1 through 20 is 100% covered by Medicare. But at day 20, the staff is going to assess. They're going to reevaluate the patient. They're going to see, for example, how is the person progressing with their therapies, whether it's physical therapy, occupational therapy, speech therapy. Now, it used to be that if somebody was determined not to make progress, that Medicare would not pay for it, but that is no longer the case. So if you have a loved one in a situation and you're being told at the rehab, oh, she or he is not making progress, that is not the end. And you can require the facility to still submit their billing to Medicare and let Medicare make the decision. Because Medicare's position is if the therapy is needed to maintain the level that the patient has reached and prevent them from declining, Medicare is going to provide coverage. For example, to maintain a functional ability for them. Also, if the patient has dementia, which may make it challenging for them to follow instruction during their time with the therapist, that by itself does not disqualify them from getting the Medicare coverage. But for everybody, no matter what their diagnosis, no matter what their illness, Medicare will stop the coverage on day 100. And at that point, we need to have a plan in place because otherwise the patient is going to have to pay privately at the private pay rate. Any questions? Let me pause for a minute and see if anybody has questions or you've heard something differently than what I've just explained. Okay. Now, what happens if the person went into the hospital, they went to the rehab, maybe they went home at that point, and then they at some point go back into the hospital? What happens? Well, if the diagnosis upon admission for the second hospitalization is different, we call it a different spell of illness, then you start your 100 days all over again. Now, ideally, it is a good idea when you're young and you can financially afford it to look into purchasing long-term care insurance. Why? Well, number one, it's going to give you options in the future about where you can get the care that you need. You can say, hey, I want to have the therapist come into my home. I want to have a home health aide come into my home. You don't necessarily, when you don't have the long-term care insurance, lose that option. And then you only have the options of having care provided in a facility. But certain generations that have come before us maybe couldn't afford it, maybe didn't understand it, so they never inquired about it, or they might have been relying on the misnomer that Medicare was going to take care of everything for them. So what do? if our elders do not have a long-term care insurance policy and we're at the point where Medicare is no longer going to cover what they need? Well, we're going to want to look at a few things. We're going to look at the Medicaid system, and if our elder was a veteran or the spouse of a veteran, we're going to want to look to see what type of veteran benefits are available to provide financing to pay for the care. Well, both programs have medical requirements as well as financial requirements. Tonight, we're going to be focusing mostly on the financial eligibility rules. Now, the rules to some extent have some similarities, but they also have differences. So please keep that in mind, because while we try to make it possible to get both benefits, sometimes we have to start off with one, and we have to select the government benefit plan that is the most advantageous, going to provide the most benefits. Now, under the Medicaid rules, and Medicaid is a federal program that the states administer, so the rules apply across the country, but there can be some additional requirements that a state imposes. Here in Florida, the limit on resources when an unmarried person seeks to apply for Medicaid assistance is $2,000. So what does that comprise? That's our bank accounts, that's any investments. If we are married, our spouse is allowed to keep more assets. They're allowed to keep $137,400. Now, Medicaid is only going to look at the income of the person applying. So if you're married, they're not going to look at the income of the spouse. Florida is one of only a few states left that actually have an income limit. And I want to emphasize that this figure of $2,523 a month is a gross figure, meaning before there's any deductions such as taxes taken out. So if somebody has, let's say, Social Security retirement benefit and they get a pension from their former employer, we have to add those two up to see, is their gross income below or is it above this limit? Now, if it is above the limit, they can still qualify, but there is a Medicaid income trust that has to be put into place. And it's important that that be done timely so that there's no loss of Medicaid eligibility. Now, not every resource is going to be counted by the Medicaid agency. So Florida, I think, is a very generous state, and one of the resources that are protected is a person's home. Now, there is a financial limit on the value, the equity of the home. It's currently approximately $635,000. So as long as the equity is less than that, the home does not count as an asset. What does that mean? Well, it means that your loved one does not need to sell their home. Nobody's going to require that. So if you hear that, that is a rumor. It also means that if they receive Medicaid, that when they pass away, the home is still protected. There will not be any Medicaid lien attaching to the home, as long as the home is going to go to family, to a spouse, to children, or to a disabled child. In Florida, we also protect a car, regardless of age or value, and we can protect a second vehicle as long as it is over 7 years old. Now, it's not unusual for people who are of retirement age to have an IRA. So Florida's rule is that if the owner of the IRA is taking monthly minimum distributions, that means they get the same sum every month consistently, it doesn't fluctuate, then Medicaid is not going to count the value of the IRA as a resource. So that's a great and a very easy way to protect the IRA. Many people may take their distribution just once a year because that's the advice they've received from their accountant, and that's fine. That's based on tax advice. And all we have to do is convert the distribution from once a year to monthly in order to meet Medicaid's requirement. Now in Florida, we have two main types of Medicaid programs. We have the nursing Medicaid program that will provide coverage for individuals that are in a licensed Medicaid skilled nursing facility. Pretty much everything is covered: the room and board, the medical services, any tests that are required, prescriptive medications. What will not be covered are personal items such as clothing, shoes, personal toiletries. Our second program here in Florida is what we refer to as community Medicaid. Years ago, it had the name of long-term care diversion, and it covers providing services by a Medicaid provider either in a person's private residence or a residence of their relative, or in an assisted living facility. Now, if somebody is living in a private residence, it mostly means that they can get a certain number of hours a week of home health services paid for by the state. If a person is living in an assisted living facility, it means that Medicaid is going to make a financial payment every month to the facility, but it's not toward room and board. It goes towards the care management services that are being provided to the resident. The resident will pay their monthly income towards the room and board component. So those are some of the differences between what is covered under the skilled nursing program as compared to the community Medicaid program. In Florida, we do not have a waiting list if somebody is applying for the nursing home program. But I do want you to know that it's important for you to get the right advice at the earliest possible time so that the application is timely filed. About a year before COVID, we used to have the ability, if somebody filed an application late, they just didn't realize they were eligible, to say to the Department of Children and Families, please give this person retroactive Medicaid. And we could ask for retroactive Medicaid for up to 3 prior months. But then our governor applied to Washington, D.C. to eliminate retroactive Medicaid, and that request was granted. So what that means is if you don't know that your loved one would qualify, let's say they were eligible in January, but you didn't file the application or you didn't go to an attorney until February or March, they are not going to get retroactive benefits for January and February. So getting qualified at the earliest possible time is very important from a financial point of view. Now, if your loved one is a veteran or married to a veteran, there is also the possibility of receiving financial support to help pay for care in the home or to pay for care at an assisted living facility. With Medicaid, Medicaid is going to pay the provider directly. So there's no money being passed through the elder's hands, it's paying the provider directly. With the program called Aid and Attendance, there is actually a financial payment being made to the veteran, which the veteran can then use to, let's say, pay for a home health agency or help pay for room and board at an assisted living. What the eligibility requirements are first that the veteran had to have 90 days of active duty. And 1 day has to be during a declared period of war. Now, Congress, and you can find this on the internet, Congress has the beginning dates and the ending dates of specific periods of war, whether it was the Korean War, Vietnam, World War I, World War II. So that's why having the honorable discharge papers becomes important, because you want to know the date of entry and the date they exited the military. Now, aid and attendance has nothing to do with whether your loved one was injured while they were serving. It is what we call non-service connected. We're just simply saying that at this time, the veteran needs assistance in order to be safe in their home environment. They need assistance to perform their activities of daily living. And what's nice is this supplements the Social Security benefit. It's not replacing it. They still get their Social Security retirement benefit. This program also has financial eligibility requirements. You'll notice that it allows the veteran to keep a higher amount of resources than Medicaid. Now, the number that you see is $129,094. That is regardless of marital status. So if the veteran is a widow, widowed, or unmarried, it's the same asset limit as for a couple where just the veteran is applying. Both the Medicaid program and this veteran program are allowed to ask on the application whether the applicant has given away assets to somebody else. With Medicaid, it's a 5-year look-back period, pretty long. With the veteran program, it's only a 3-year look-back period. So what does that really mean? It means that if assets have been given away during that period of time, then the applicant will not be eligible right away for either Medicaid or veteran benefits. What the caseworker will do is they will calculate what is called a penalty period, a period of time that the applicant is not eligible. And they have to wait out that time. When that time has run, they can come back to the agency, whether it's the Medicaid agency or the Veterans Administration, and they can reapply, and at that time be approved to begin to receive benefits. Now, has anybody heard the word fiduciary before? It's kind of a strange sounding word, and it means a person who has been entrusted with a level of care, of being responsible for another individual. And we're about to talk about documents that can help our loved ones avoid going through the court process called guardianship. These are documents that help us and our family members be able to make medical decisions and financial decisions during these challenging times. So fiduciaries can be the healthcare decision maker, the financial decision maker. It can be a guardian appointed by a court. It can be a trustee. A fiduciary can be a person such as you and I, or it could be a professional such as a trust company. What is key here is that the fiduciary is held to a high standard of care in making decisions. They have to act in the other person's best interest, not in their own best interest. So the first document that we're going to talk about that everybody needs to have in their toolbox is a durable power of attorney. Now, the word durable is important because it means that this is a document that's going to continue to work even when your loved one becomes incapacitated. So it is a way of giving permission to make financial decisions. It does not make you, as the fiduciary, an owner of their assets, and that should hopefully allay any concerns that they have about giving you authority to help handle their financial affairs. So one example that I give is if an elder has a concern that an adult child might go through a divorce, or perhaps has their own business and the business is not doing well, and they may need to file for bankruptcy, that by giving that adult child the power of attorney, it actually protects the parent. It is not making the adult child a co-owner of the parent's assets. So the asset is protected in the event of the fiduciary's divorce or the fiduciary's bankruptcy. This is a much safer way of handling things as opposed to putting the adult child's name on an account as a joint owner. Then there's no protection if there's any financial hardship that the adult child experiences. Now, back in 2008, Florida made a major overhaul of our durable power of attorney law. And since then, when an attorney writes this document, we have to explain to clients that there are very high levels of decision making that the client has to decide, are they going to give this kind of decision to their trusted person or not? And we refer to these as superpowers. For example, does your parent or grandparent want to give you permission to create a legal document called a trust if that would be beneficial for them? Would they like to give you permission to make gifts of their assets when they're incapacitated? Some people may decide yes because they've had a past history of giving gifts at holiday time or birthdays or special occasions such as weddings or graduations, or they might make charitable donations. They might tithe to their church or their synagogue, and so they may want that to continue. So these are just a few examples of superpowers that need to be discussed so that they can then be written in the document to meet the needs of your family member. Now, it doesn't matter what a person's marital status is. Everybody who's an adult over the age of 18 should have a durable power of attorney. It's a myth to think that if we're married and we're incapacitated, that our spouse is going to be able to make financial decisions for us. And the reason that's a myth is because each of us might have an asset that we own that our spouse's name isn't on or can't be on. For example, if you're working, you might have an IRA, or perhaps your employer has a 401k plan that you participate in. Well, a spouse can never have their name as a joint owner on a retirement plan. So if we became incapacitated, they cannot call up the plan administrator and say, my spouse is ill, I need to take out $5,000 to help pay for their care. The administrator is going to say to them, okay, in order for me to speak with you, I either need to see your spouse's power of attorney giving you permission, or I need to see a court order that makes you their guardian. And without either of those documents, there's no way that our spouse is going to be able to access any assets that they are not a joint owner of. Now, let's say you are the fiduciary under the durable power of attorney. How do you get your authority recognized? Well, the first thing is that the bank or the financial institution is going to ask you to sign an affidavit that says your loved one is still alive. And the reason that is important is because the power of attorney only works while we are alive. When we pass on, it ends and we can no longer use the document. The other thing that the affidavit is going to say is that the elder has not changed their mind. They didn't cancel the power of attorney and take the authority away from you. It will also say that, to your knowledge, there is no guardianship in place for the elder. Otherwise, if there's a guardian, the guardian will probably be the one making the financial decisions. So that's the primary way that you have your authority under the document recognized. They will also ask you for a photo ID as proof that you are who you say you are. And any bank is going to submit a copy of the durable power of attorney to their legal department to review before they will recognize your authority. Now, the other very important document to have as part of this plan is the designation of healthcare surrogate, because we have this other side of our life, which is the medical, the healthcare, where am I going to live? And so if your loved one is, let's say, unable to communicate, they're having trouble understanding what the doctor is explaining, and they're not capable of giving informed medical consent, well, then that's the time for the surrogate to step in and be the medical advocate. So imagine the surrogate is standing in the shoes of the person that is not able to make their own medical decisions. Now, with both the power of attorney and the healthcare surrogate, it's important to name more than one person. We want to have a backup plan. And you can have and name as many alternates as you want. The whole point is that we have a plan that will not fall apart. So if the primary person that has been named unexpectedly gets sick or unexpectedly dies, our plan doesn't fall apart. We have another person named, ready to step up and take on the responsibility. So when you're having the discussion with your loved ones, it's important to talk about naming multiple people, but most importantly, match the personality and match the skills of the person with what they need to do. Not everybody is cut out to be the healthcare surrogate. Some people don't work well in a medical emergency situation, but they might do great being the financial decision maker. So it's really important to match the personality and skill set with what the person is going to need to do. Now, in 2015, Florida expanded its law, and we can now, in the document, allow the client to choose when they want their surrogate to actually start making decisions. The choice is either immediately or only when their doctor determines that they are no longer capable of giving informed medical consent. So that's a great option that we didn't previously have. Another option has to do with when do we want to give the surrogate access to confidential medical information? Do we want to give them the access now, immediately, or do we want to hold off until the doctor says that the elder is not able to give consent? So these are things to think about because we want to cover them when we're writing the surrogate. So exploitation has become a hot topic, especially since the beginning of COVID, mostly because people were alienated, they were by themselves. For many families were out of state, so there was nobody to check in on them, no support network to watch over them. And so, I want to talk for a few minutes about how do you know when exploitation is occurring? What are the warning signs? And what do you do? What are the resources available to help somebody that you know who might be in the process of becoming a victim? Now, exploitation takes a lot of different forms today. I will tell you that I have seen more sophisticated scams due to COVID than I ever did before. And exploitation can be committed by anybody. It could be by a stranger, it could be by a neighbor, it could be by people we know. The key is that exploitation takes place usually through either intimidating the victim, telling them, hey, if you don't acquiesce and I'm your primary caregiver, I'm just going to leave and then you're going to be alone. Or it occurs because there's deception. People are told something that is really not true. They might get a knock on the door and a salesman is there telling them, hey, you need a new roof. And they really don't, but they don't know better. And so they're being deceived. Another form of exploitation is when a victim is being conned into giving away their assets or altering their will. All of a sudden, they're being told by a friendly neighbor or a new girlfriend or a new boyfriend, you know, put me in your will. Look how much I've done for you. I'm going to take care of you. So you want to watch out for those kinds of signs as well. Another warning sign would be learning that somebody you know has signed over a deed. They have transferred ownership of their home to a stranger, to a neighbor, without receiving the actual value of what the home is worth. Exploitation can also be in the form of adding the perpetrator's name to financial accounts, which now gives them direct access to clean out the accounts. Watch out for telephone scams. I've seen a lot of this the last 2 years. And when people are experiencing cognitive impairment, it's a very gray line. They can't distinguish right from wrong. And I had a client whose husband had significant cognitive impairment and he was getting calls on his cell phone. It started out with him being told that he had won a lottery of $13 million. Now, mind you, this gentleman had never bought a lottery ticket, had never entered a sweepstakes. And the woman on the phone told him that Homeland Security was holding the money for him. And in order to release the money, he had to first pay the taxes up front. So that was the storyline they used to get him to send them hundreds of thousands of dollars. There's also computer scams, and many of them can fool you and I. They look legitimate. They have a familiar logo, such as Microsoft, on it. And so you've got to be very careful. Make sure that you have antivirus software. Make sure you might even need a firewall if you have an elder living with you in your home. Because if they click on it, not only could it release a virus into your computer system, but then it could access financial information or financial data. So be very careful. There's also in the last year been a scam where people get these letters saying that they owe the IRS money when they don't. If you have any concern, just call the IRS directly, call Social Security directly. If you have any doubts, look at things a second time before you take any action. So what are some of the legal tools that are available if the exploitation has already taken place and what you're trying to do is stop it from continuing? Well, one of the first tools that we need to access is we need to go to court and file for an emergency temporary guardianship, because this is going to give you the ability to turn off all the financial accounts. It's going to put a freeze, a hold on all assets so that there is no longer any access by the perpetrators. Now that emergency guardianship will last for 90 days because it's meant to stabilize a situation. At the end of the 90 days, there's going to be a hearing for the judge to determine whether or not there is a need for a permanent guardianship to continue. And so then we explore whether there's a need for a plenary guardianship, meaning that the elder is not capable of safely exercising any of their legal rights. Another option might be that they might be capable of exercising some rights, but not all. So then we would seek a limited guardianship where some rights would be kept by them and other rights would be given to you as the guardian for making decisions about property or making decisions about medical and residential issues. The other tool that we use for exploitation is called an injunction to protect a vulnerable adult. And this is where we file a petition giving the judge facts about the exploitation that has occurred. We might need to attach copies of forged checks or other things that show that the money is coming out really without the elder understanding or giving true permission to the perpetrator. So this also stops the perpetrator. This will go to the sheriff and the police department to serve on the perpetrator. It may also be that we want to ask for a restraining order to prevent that perpetrator from coming near the elder who has been victimized. Now, sometimes exploitation is committed by the person that was given the durable power of attorney. They have misused their authority. So we can ask in that situation the judge to suspend the authority under the power of attorney, or we can ask the judge to terminate the authority and no longer allow them to use that document. And last but not least, we can bring a civil cause of action if somebody has misused their fiduciary authority, and if they still have the assets, get that money back. The key is noticing the warning signs as early as possible so that you can get intervention as early as possible. So you want to reach out to your local police department, your local sheriff, to have them investigate. They are the ones that can then go to the state attorney's office to charge the person with a crime and arrest them. In Florida, we do have an abuse hotline that I'm giving you the phone number and the website for. What they will do is they will take the report and then they will transfer the report down to the appropriate county level for an investigator to be assigned to go out and investigate the abuse, the neglect, or the exploitation. There is a National Fraud Information Center that you can make a report to. So if, let's say, a credit card was compromised, you can report it to the National Fraud Center. Adult Protective Services is under the Department of Children and Families here in Florida, and they conduct the investigation when there is a report of abuse, neglect, or exploitation. You may also want to turn to Jewish Family Services or Catholic Charities to get assistance while the investigation is taking place. And if your loved one is a member of the LGBTQ community, here in Broward, we have SunServe, which is the local social service agency that can provide support. There is also the National Center on Elder Abuse, and they provide training. So if you work for an employer, that it would be beneficial for them to have a training session for their employees so they know what to look for their family members and their neighbors. They have great training materials that are available. And there's also the National Center on Law and Elder Rights. So I want to leave you with some tips. How do you have the conversation? Now, earlier I said you have to have reasonable expectations. You can't expect to just sit down one time and have it well received. Many times it's going to take several conversations. So you've got to do it in small doses. You know, if you've ever heard somebody say, how do you eat an elephant one bite at a time? It's like peeling the layers of an onion. You peel back one layer and there's another layer below. You don't want to overwhelm your family member, and you certainly don't want to be overwhelmed either. So when you do sit down to have the conversation, remember to be compassionate. Think of how would you want your child to approach you. Number two, accept their initial reaction. Accept and respect how they feel. Sometimes people just need to know that they're being heard rather than being ignored or feeling like somebody else is going to make their decisions rather than involving them. And don't forget to have empathy. And it might be challenging to think of what it's like to be in a body that's 80 or 90 years old, to be a widow or a widower. But the more you can empathize, you're going to find that it really opens the dialogue and opens the lines of communication. So a couple of tips to help you and your loved one prepare for an elder law consultation. Gather the financial documentation. Have it organized. Know what the assets are, the income and the liabilities. Encourage your family member to write down their questions. What are their concerns, their fears, and what are the goals? What is it that you want to achieve? Starting to think about this before you meet with the elder law attorney will really make it an effective planning meeting. Now, I know that some people still are not comfortable because of COVID meeting in person, so it might be a video consult, or they might prefer to meet in person. It's important to make sure that your loved one is going to be able to participate as effectively as possible. So please remember, if they need reading glasses, bring them. If they use hearing aids, make sure that they are fully charged and working. And simply just be honest. You know, when you're with the attorney, you need to talk about any family member that you're concerned about who might have a disability, special needs, or might even have an addiction. Because the more information the attorney has about the family member, the better they're going to be able to advise your elder, your relative, about whether or not that person should be a fiduciary, and how can your elder leave an inheritance for that person in a way that's going to be safe and safeguarded. So at this time, I'm happy to take any questions that anybody has.
You have given me a lot of information that I'm trying to digest. At least I've got a good starting point. So I really appreciate your time tonight.
You're very welcome. So as I mentioned, I am recording this evening's webinar. It will be available. You can go right on the website and watch it or share it. I am hosting several in-person educational presentations this month. That is also on the website. And I appreciate that you took time out of what I'm sure is a very long day. Please go on the website. There is a complimentary gift certificate that you can use for a consultation. And, you know, we offer the consultations both by video as well as in person. So I want to wish everybody a good evening, a healthy 2022, and best of luck as you navigate through the aging process with your loved ones?